Good luck.
All right. Good afternoon or morning, depending on where you are. I have a script, so I will read this. We are waiting for a few people before we get started. Are we waiting for anyone else? Gentlemen?
Nothing to wait for from the plaintiff, Your Honor.
That's
All right.
here, Your Honor.
Grand. Then we will get started. We will call the case of Marks v. Sonny's Rooftop Bar. My name is Judge Eslick. We have presiding judges, scoring judges here as well. Scoring judges, please look to the two buttons on the lower left of your screen and turn off your audio and video. And these should remain off until the trial ends. You should also have your video set to hide non-video participants. And this means the only people on the screen right now should be the advocates and me. Can the attorneys please make their appearances?
Yes, Your Honor. Good afternoon. My name is Bennett Demsky. I'm joined today in court by my co-counsel, Ms. Fatima Lawan.
Good afternoon, Your Honor.
Together, we represent the plaintiff in today's case, Ms. Ethel Marks, on behalf of her daughter, who is deceased, Jessica Marks.
And for the defendant?
Good afternoon, Your Honor. My name is Sahul Nerurkar. I'm joined by my colleague, Ali Alekri. Together, we represent the defendant in today's case, Sonny's Rooftop Bar.
All right, I see you. Are there any preliminary matters?
Yes, Your Honor, just two from the plaintiff. First, we'd like to let Your Honor know that we're going to be using some physical demonstratives of actual drinks that were consumed that night throughout today's trial. We'd ask Your Honor's permission to use those in opening statement, along with one exhibit, Exhibit 2, which is a photo of the decedent. We've got a good faith basis to believe the photo is going to come into evidence on the first witness, and we just like to show the jury the decedent in openings.
Any objections?
Your Honor, we may have an objection if they intend to use the demonstrative to put testimony on the record, but if they're just using it for demonstrative purposes, no objection at this time. We similarly have no objection to the photo of Ms. Marks. We agree that it'll probably come in on the first witness anyway.
Okay, then you can use those exhibits for those purposes.
Yes, Your Honor. I just want to be clear, these drinks aren't exhibits. They're just for demonstrative purposes only.
I think we have an agreement.
And secondly, Your Honor, we just like to make the court aware that Exhibit 22, the decedent's autopsy report in this case, has been pre-admitted pursuant to stipulation by both parties. We'd ask the court to take judicial notice of three facts contained within that document pursuant to 201. First, that the decedent's age was under 21. Second, that the decedent was 5 feet tall. And third, that the decedent weighed 110 pounds. These facts can be readily and easily determined from the report that's in evidence, and their accuracy is not in question.
All right, I don't know if I can do that because those facts aren't publicly available, but if defense has no objections, then.
Your Honor, we agree with those facts anyway, so we have no objection to them getting those facts on notice.
All right.
With that, Your Honor, plaintiff's ready to go.
Anything for the defense?
Yes, Your Honor, just a couple things. First, pursuant to Rule 615, we just moved to sequester the plaintiff witness, Morgan Levin, from opening statements. Our witness is our party opponent, so we won't be sequestering him today.
Without objection.
All right, so ordered.
Next, Your Honor, since we intend on sharing our screens at multiple points in today's trial, we just wanted to make sure it's okay with Your Honor if we just note for the record what we're doing, or if you'd like us to ask permission instead.
No, you don't have to ask permission, but I would like you to tell me what you're doing. And that way, if it doesn't show up, you know, we know what was supposed to happen and we can fix it.
Yes, Your Honor. And lastly, we expect to be referring to a deposition in today's case of someone named Kendall Roitman. We just wanted to make Your Honor aware that pursuant to pretrial order 12, Kendall Roitman is unavailable pursuant to 804A, and pursuant to pretrial order 24, that deposition has already been agreed by both parties to be authentic.
May I respond, Your Honor?
Yes, go ahead.
So, Your Honor, we certainly understand that that document is qualifying under the unavailable declarant exception to the hearsay rule. There are portions of that document that we believe are character evidence or hearsay within hearsay or a relevance objection. So we may object in trial if they read certain portions, but we understand that it is authentic and that it fits the bill under 804A.
Okay, so let's do this. I mean, the document itself, if it's authentic and is subject to an exception or exemption to the hearsay rule, we'll let it in. By in, I mean you can talk about it, but if there are specific objections to the portions that you're going to read, we'll deal with that on a case-by-case basis.
That's totally fine with the plaintiff, Your Honor.
All right. Anything else for the defense?
That's all from the defense, Your Honor. With that, we're ready to proceed to opening.
All right. So I think we're ready to go. We have the sequestration order in place. And despite my casual appearance today, I do run a tight ship, but it's my one day of the week not to wear a tie. So I look forward to this round. Good luck. Plaintiff may proceed.
Mr. Nerurkar, may it please the court. What the defendant served, what they saw, and what they said, those are the keys to understanding this case. A beer, a mixed drink, a shot, 1, 2, 3 hard seltzers, an entire bottle of wine. On March 24th, 2019, this is how many drinks the defendant, Sonny's Bar, served to a 5-foot-tall, 19-year-old girl named Jessica Marks. Could we put a photo of Miss Marks on screen, please? This is Jessica Marks. She loved music. She was a criminology major at Drexel. She leaves behind a mother and a brother who love her very much. On March 24th, 2019, you'll learn that this defendant served Jessica Marks 6 drinks and an entire bottle of wine in less than 2 minutes after she pulled out of the bar parking lot. Her car was smoking at the bottom of a ravine with her inside. What they served, what they saw, what they said. The evidence today is going to show that the defendant served Jessica Marks all these drinks. The evidence today is going to show that the defendant saw just how intoxicated Jessica was. The evidence is going to show that this defendant said out loud that Jessica was too drunk to be driving. But despite all that, you'll learn today that this defendant never stopped giving Jessica drink after drink after drink. That's why we're here today. That's why Jessica's mother, Ethel Marks, has sued the defendant for wrongful death under the California DRAM Act. Because even though Jessica made the awful choice to drink and then get behind the wheel, the law says that if a bar like Sonny's serves alcohol to a minor and then keeps serving them and then keeps serving them and then keeps serving them, and somebody gets hurt because of it, they can be held liable. Today, we're going to prove to you by a preponderance of the evidence, that means more likely than not, that 1, Sonny's Bar served Jessica alcohol even though she was obviously intoxicated. That 2nd, those drinks caused her death. And 3rd, that she was under 21 years old at the time, which is something everyone here agrees is true. We're going to prove our case, ladies and gentlemen. And we're going to do it by asking you to focus on what the defendant served, what they saw, and what they said. So first, what the defendant served. We're going to call Jessica's best friend, Morgan Levin, to the stand. Mr. Levin will walk you through the events of March 24th, 2019, and through his testimony, we're going to show you how the defendant served Jessica all the drinks behind me, the beer, the mixed drink, the shot, the hard seltzers, the wine. Mr. Levin will tell you that Jessica drank them all. That brings us to the second thing, what the defendant saw. You'll learn today that Jessica was 5 feet tall. She weighed only 110 pounds. You're going to see video evidence that after just a few of the drinks behind me, Jessica was slurring her words. Her eyes were bloodshot. She could barely sit up straight. And we expect Mr. Levin to testify that this defendant served her anyway. Finally, members of the jury, we're going to tell you about what the defendant said. You'll hear that the bar staff that night knew how dangerous this situation was. You'll hear they said out loud that they needed to stop Jessica from drinking more, but didn't. You'll hear they said out loud that they knew Jessica shouldn't be driving, that they should stop her, but wouldn't. You're going to learn from Mr. Levin's testimony that the defendant kept those drinks coming all night long, that the defendant kept these drinks coming even after Jessica was too far gone to do anything at all. That's why at the end of this trial, I'm going to come before you again. I'm going to remind you to think about what the defendant served, what they saw, and what they said. I'm going to ask you to find Sonny's Bar live. Thank you.
Thank you, counsel, for the defense.
Your Honor, can you see and hear me all right?
I can.
May it please the court. Mr. Demsky, members of the jury. Everyone agreed that she could drive. As I was listening to Mr. Demsky speak to you a moment ago, I recognize there's plenty of things we disagree about. We disagree that Jessica Marks was obviously intoxicated that night. And we disagree that Sonny's rooftop bar is to blame for her death. But as I was listening to Mr. Demsky, I also recognize there's a lot of things that we as the defense totally agree with. We agree that what happened to Miss Marks was a tragedy. We agree that she was drunk when she got into her car that night. And today, members of the jury, you're going to learn that we and the plaintiff also agree on what happened right before. That as Miss Marks got into her car, everyone around her agreed that she was sober enough to drive. And that's a problem for the plaintiff, members of the jury, because it's their job today not only to prove that Miss Marks drank that night, not only to prove that she was drunk, it's their job to prove to you that it's more likely than not that she was obviously intoxicated. Now, what exactly does obviously intoxicated mean? Well, the law tells us that someone is obviously intoxicated when a reasonable person looks at them and can see that they're drunk, can see that they're obviously drunk. Now, as the defense, we don't have a burden in today's case, but we're going to take a closer look at how obvious Jessica Marks's intoxication was. We're going to bring you not one, not two, but 5 accounts of people who were there that night and didn't think she was too drunk to drive. First, you're going to hear from one of the plaintiff's own witnesses, Morgan Levin, Miss Marks's best friend. You're going to learn that as they left the bar that night, both Morgan and Jessica agreed that Jessica could drive. You're also going to hear from the bar's owner, Mr. Mehta. He's going to take the stand himself and say that both him and his employees agreed that when they saw Jessica leaving the bar that night, they weren't worried about her driving. And members of the jury, you're also going to hear about other customers, people who were there that night, who saw Jessica drinking, who saw Jessica leave, and agreed that she was sober enough to drive. The owner, the bartender, the customers, the friend, and the driver. These are 5 accounts that you're going to hear about today that are different in many ways, but all agree about one thing: that when Jessica Marks came down from that rooftop bar, when she took her keys out of her purse, when she opened her car door and got in, that they weren't worried. Now, Mr. Demsky a moment ago told you that this case is all about what people saw and what people said. We agree. So, members of the jury, as you listen to those 5 accounts, listen to what the people at the bar saw and listen to what they said. We're confident that after you hear their accounts, you'll see that Jessica Marks wasn't obviously intoxicated, that the plaintiff will fail to meet their burden, and that we'll ask you to find Sonny's rooftop bar not liable. Thank you.
Thank you, counsel. Just so I know, is this trial bifurcated?
It is, Your Honor.
All right. Any evidence from the plaintiff?
Yes, Your Honor. Plaintiff calls its first witness, Morgan Levin, to the stand.
All right.
May I proceed?
Yes, I can see you. Can you say something so we can hear you?
Yes, Your Honor.
No, Morgan. Sorry.
How's it going, everyone?
Great. All right, proceed.
Good afternoon. Can you please introduce yourself to the members of the jury?
Good afternoon. My name is Morgan Levin.
What do you do, sir?
I'm a student. I just finished my junior year at UCLA.
Do you know why you're here in court today?
Yeah. Back in 2019, my best friend and I, we went to a bar, we drank, and that night I took an Uber home, but she drove. She got into an accident and died. I'm here to talk about what happened that night.
Let's go back to the beginning. Mr. Levin, I want to talk some about Jessica Marks. Would you recognize a picture of her?
I would.
Let's get Exhibit 2. Sir, is this Jessica Marks?
Yeah, that's from our high school graduation.
Plaintiff offers Exhibit 2.
Any objections other than the obvious criminal offense with a mixed drink at a high school graduation party?
Your Honor, from reading this witness's deposition, we actually understand that to be a non-alcoholic fruit punch. So given that knowledge, we'd love to hear that on the record, just for the jury's knowledge, but we have no objection to it.
All right, that's good to know given the context of this case. If there are no objections, Exhibit 2 is received.
Sir, is that drink alcoholic?
I don't think it was. I'm pretty sure it was a non-alcoholic drink.
So can you tell us a little bit more about your friend, Jessica?
Yeah, she was my best friend. We were pretty tight all through middle school and high school. We visited each other pretty often too when we were in college. We did almost everything together.
I know this might be difficult for you, sir, but I want to talk about the night Jessica died. What day was that?
March 24th, 2019. We were on spring break. She came out to visit me in UCLA.
You said you went to a bar. Where?
It was Sonny's rooftop bar in Malibu.
What time did you leave to go there?
Jessica and I met up at her Airbnb a little bit earlier, but we left for the bar around 8:30.
Ms. Lawin, can you put that on our timeline, please? So you left around 8:30. Who drove to the bar?
Jessica. She had rented a car. I don't have a car with me in college, so she drove us to the bar.
I want to talk now about what happened when you got there, starting with the drinks Sonny's bar served you and Jessica. Mr. Levin, can you tell us what the first drink you and Jessica ordered that night was?
Yeah, we ordered a bottle of wine.
I'm going to put a bottle of wine in the cabinet behind me just to indicate all the drinks that you say were ordered that night. You said you ordered a bottle of wine. What'd you order next?
As the night went on, Jessica ordered 3 White Claws. That's hard seltzer, and we got a few beers.
I'm putting 3 hard seltzers and 2 beers into the cabinet. Did you order anything else?
Yeah, We ended the night with some shots.
How many?
2.
I'm going to put 2 shots into the cabin. Sir, of all these drinks behind me, how many did you have?
I had 1 glass from that bottle, 1 of the shots, and I had 1 of the beers.
I'm going to take a shot and a beer out of the cabinet. And sir, the rest of the drinks in here, who are they for?
Those were for Jessica. She drank them all.
Did Sonny's bar serve Jessica anything else that you remember?
Not that I saw. At some point, she went into the bar, came out with a dark drink that had a lime in it, but nothing other than those drinks.
I'm going to place another drink behind me as well.
Objection, Your Honor, to lack of foundation, if I may explain.
Right, I'm confused too. Go ahead.
If I understand the purpose of the plaintiff's demonstrative here, it's to count up the number of alcoholic drinks that Jessica Marks drank that night, going directly to their burden. So to add a drink there that we don't know is alcoholic or not, at this point, it lacks foundation.
Counsel?
Yes, Your Honor. The witness just testified that Jessica Marks came out of the bar holding a dark drink with a lime in it. Certainly, that's enough foundation for him to say that it was a drink she had obtained in that bar. We don't expect you're going to hear any evidence today that she had, limes in her pocket or brought any drinks with her.
Well, there's no lime in your drink besides, but any further response?
Yes, Your Honor. The fact of the matter is, if that was a glass of Coke, for example, or Pepsi, that would be something that the jury might confuse with a cocktail or something else. In fact, we're going to hear from the bar owner later in today's trial, and he'll be able to confirm that that looks exactly like what a glass of soda, which is available at their bar, would look like.
Counsel, what relevance does the Diet Coke or whatever behind you, what relevance does that have towards your dram shot claim?
The relevance is that it was alcoholic. Ms. Marks told this witness that it was a rum and Coke drink she'd gotten in the bar.
Right, but who said it's alcoholic?
She did, Your Honor. She was told that by the bartender. Now, we're not intending to introduce that inadmissible hearsay into the record today, but we are trying to put the drink up.
Okay, so if the foundation you need is inadmissible hearsay to make the drink relevant, why should it be allowed?
Because, Your Honor, we're happy to stipulate that we don't know whether or not this drink was actually alcoholic. We're just putting it up here to show that it was another thing that Ms. Marks was given at the bar that night.
The objection is sustained. You can remove the drink.
Yes, Your Honor.
And if you have appropriate foundation later, then you could put it back up.
Yes, Your Honor. Mr. Levin, we've talked about the drinks that were served to Jessica. I want to talk now about what the bar staff saw of Jessica that night. Sir, was anyone serving you while you were there?
The bar owner, Sonny, he's the one who served us.
And how many times would you say Sonny came up to your table that night?
I can't say exactly, but I think it was around 8 or 10 times, 8 to 10.
So during the course of those interactions over the entire night, did Jessica seem to get more drunk?
Yeah. Her eyes were bloodshot, really watery. She was slurring her words. She didn't really have a great balance. Yeah, she definitely got more drunk as the night went on.
Let's put up Exhibit 10.
Objection, Your Honor, to a lack of foundation to the witness's last add-on to the question there that she definitely got drunk as the night went on. We don't think that is supported by what he said earlier in his answer about just the physical symptoms she showed.
May I respond?
Yes.
The witness testified that her eyes were bloodshot and watery, that she was slurring her words, and that she was stumbling and was wobbly. Certainly, those are physical characteristics one displays when they're intoxicated. This witness has foundation to say he believed that Jessica Marks got drunk as the night went on.
Okay, and so what rule would allow me to permit that into evidence?
701, Your Honor.
Okay, and it would seem to be based on a rationally based perception and
Absolutely.
within the knowledge of a lay witness. Counsel, do you have anything else? Defense.
Yes, Your Honor. Just that in this case, the distinction between how drunk someone seems and how drunk someone is a crucial distinction in today's case. And the fact that the witness just conflated those two things in his answer, that's what we have a problem with here. And we think that given the nature of this case, it's problematic.
Yeah, I sort of agree, but I'm going to allow this in because if my memory is correct, the witness said that this person appeared to be something, which is this person's observations. So the objection is overruled. We've got Exhibit 10 up. I'm assuming that all the non-admitted exhibits are being shown constructively, right?
Yes, Your Honor.
All right, go ahead.
Sir, do you recognize what's on screen?
Yeah, that's a video. Looks like the snapshot of a video that Jessica posted on Instagram.
Does the snapshot look fair and accurate?
Yeah, it does. It was posted at 11:11 that night.
We offer Exhibit 10 and we ask to play it for the members of the jury.
Any objections?
Your Honor, pursuant to stipulations, this is an authentic, excuse me, this is an authentic video, so we have no objections.
All right, let's press play.
Hang on.
Morgan and I.
No, go ahead. That's fine. If it's a stipulation, that's fine, but there are all kinds of objections to this. But if the parties have stipulated, go ahead.
We're in Hollywood. We're in a bar. It's kind of like a Philly bar, except everything is really, really expensive. $10 for a seltzer. And everyone here wants to be a model or an actress. You know, I'd like to thank the Academy. Mom and Dad, you've inspired me. Okay, well, go big or go home.
Mr. Levin, let's move on to the third thing. What the people at Sonny's bar said to Jessica. Did the two of you ever get up from your seats?
Yeah, we did. Later in the night, we got up from our seats and went downstairs to use the restroom.
Did anything happen to Jessica when you went to the bathroom?
Yeah, at some point she stumbled, lost her balance. She looked like she was gonna fall, but she kind of caught herself on the railing.
Did any of the bar staff see her fall?
Yeah, Sonny did. Jessica practically fell right on him.
What did he do?
He turned to the other bartender and said, whoa, Frankfurt, we might need to cut this one off.
Did Sonny Mehta say anything else to you that night about how drunk Jessica was?
Yeah, later in the night, he said, Jessica went to order another drink and he looked at me and he pointed at Jessica and said, I hope this one's not driving.
Sir, after they said they needed to cut Jessica off and that they hoped Jessica wasn't going to be driving, did they serve her more drinks?
Yeah, they did.
I want to talk now about the end of the night. How were you planning on getting home?
So around 11:45, we were leaving. Jessica wanted to drive. I didn't want to drive with her because she looked drunk. So I took an Uber. I tried to stop her. I should have stopped her, but I couldn't.
What happened after Jessica got in the car?
I watched her pull out into the road. She was in front of the Uber I was in. And barely a quarter mile away from the bar, she just swerved across the divider and just went off the road. Then I found out that she died.
Thank you for your time, Mr. Levin. Nothing further right now, Your Honor.
Is there a cross?
There is, Your Honor. May I proceed?
Yep.
Good afternoon, Mr. Levin. How are you today?
Not great, to be honest, but I can answer your questions.
I appreciate that. I want to start by asking you about what you just told the jury on direct examination. You described Jessica's behavior that night, right?
Yeah, I talked about it a little bit.
You told her she was acting in a way that seemed drunk to you.
Yeah, I know Jessica pretty well. She seemed drunk that night.
But I want to be clear about something. You mentioned that Sonny Mehta, the bar owner, had spoken to you 8 or 10 times that night.
Something like that.
And yet not once during those interactions did Jessica seem drunk, right?
I don't know.
Sir, true or false? You can't remember a single instance of Jessica showing symptoms of being drunk in front of the bar employees.
I can't think of one specifically, no.
So all of those 8 or 10 times you mentioned remembering Sonny Mehta coming and speaking to you, you didn't think Jessica was showing signs of being drunk.
I don't know if she wasn't showing signs or not. I don't remember looking at Jessica when Sunny came over to serve us drinks or take our orders.
To redirect you back to my question, sir, you can't tell us for sure that she was showing signs then.
I know, I can't tell you that.
Mr. Levin, you agree with me though, your memory of that night, it isn't perfect.
No, it's not perfect.
You drank a lot that night.
Not really. I had a beer, a glass of wine, and one shot.
Hold on, sir. Is it your testimony that you only had 3 drinks?
Only had 3 drinks at the bar. Before I came to the bar, I had another glass of wine.
But sir, is it your testimony that you drank less than Jessica that night?
Yes.
So if there was someone who was there that evening and saw you drink the same amount, that person would be lying?
Objection. It's argumentative.
How is it argumentative?
Because he's asking about whether or not another witness would be lying if they saw something else. That's for closing, Your Honor.
All right. Defense counsel, there are all kinds of rules on whether someone can comment on the credibility of another person. Can you educate me on why this should be allowed?
Yes, Your Honor, because it's not going to speak to someone's character or character for truthfulness. It's just going to 2 statements that are contradictory. If he believes one, he has to believe the other one is false. And my question just goes to that.
Right.
Response?
But, well, you're going to win, but you can respond.
I was just going to say, Your Honor, that is not admissible. He can't ask this witness to make a determination about another witness would say about whether or not he was telling the truth or lying based on what they saw.
All right. So you can ask. So the question is the person a liar, which is a character issue. Whether the person said contradictory things is different. And so you can ask about the latter, but asking this witness to comment on whether someone is a liar without additional foundation as required by the rules pertaining to comments on people and their credibility, I'm not going to allow. So the objection is sustained, but I think you can fix this with a different question.
Yes, Your Honor, I'll rephrase.
Yes, Your Honor.
Mr. Levin, if someone who was also at the bar that night says they saw you drinking as much or more than Jessica, that person would be wrong?
I mean, I don't know. I didn't drink any more than I said I did.
Your Honor, at this time, we ask permission to read a selection from the deposition of Kendall Roitman, the one I mentioned in pretrial.
Okay, and I'm assuming if there are objections, plaintiff's counsel, you'll bring this up as we go?
Yes, Your Honor. We'll need to hear the deposition testimony to know whether or not we want to object.
All right, do you know what portions they're going to read?
No, Your Honor. I'd like the line numbers from Mr. Nerurkar if he wouldn't
Yeah,
mind.
let's
Happy
do
to do
that,
them.
because under the rules, you're supposed to do that anyway.
Yeah.
Well, at least the federal rules.
Your Honor,
I don't know about trial by combat rules, but go
happy to
ahead.
do it.
Page and line.
Yes, Your Honor. First, for foundation, we're going to be referring to page 2, lines 13 through 16, and then substantively, page 4, lines 11 through 16.
Okay, I'll let plaintiff's counsel look at those and see if there are any objections.
One moment, Your Honor.
That's fine. Is there a time limit, or do we have to? I'm assuming we have a bailiff somewhere, but I don't want to run into any time issues.
Time is paused during this time.
Got it. Okay. I don't
Hey,
want to all off everyone.
Counsel said 11 through 16.
Yes.
I heard 11 through 60.
16, Your Honor.
16. All right.
A lot less to read. We appreciate that.
Well, and there aren't 60 lines on a page in a deposition, so I'd be surprised if there were a line 60.
We've got some foundational issues on line 16 as to how this witness would know what the friend was drinking, if Your Honor has the deposition up.
I don't. Can someone screen share that?
Yes, Your Honor. Mr. Lecker, if you could just get up, I think page 4.
Yeah, so we've got no issue to the foundational stuff on page 2.
Okay. And let's look at page 4.
Oh, they've kindly redacted the section that I had the issue.
Yes, Your Honor. I was going to say we've redacted a portion of the statement. We were going to let Mr. Demsky know about that, exactly because of the problem he had cited.
All right, and this is why the rules make you show this stuff to your opponent in real life beforehand. Are there any objections to the part that is shown right now?
Without objection to this section.
All right, go ahead and proceed. And
Mr.
is this being offered into evidence? Or is this being used as
The
a
deposition.
demo or something to read?
Yes, Your Honor, we're reading the statements from the deposition onto the record, but we're not admitting the whole deposition itself into evidence. It's too many evidentiary matters.
Okay, proceed.
Mr. Lecker, if you go to the first page. Question. We're here to talk about an incident that occurred on March 24th. Where were you at 9 p.m. that night? Sonny's, watching the end of the Lakers game. They wheel a TV onto the roof when the games are on. Next page, Mr. Leckery. Speaking about Jessica Marks. Question. Tell me every drink you saw her have. She had a couple White Claws. She had a beer or two. There was a bottle of wine on the table. I think she had a couple glasses of red wine. And her friend? Question. Answer. Same. Plus maybe more. Thank you, Mr. Leckery. You can take that down now. Now, Mr. Levin, you also mentioned that you saw Jessica fall down the stairs onto Sunny Meadow. You said that, right?
She didn't like fall all the way down the stairs. She tripped and almost fell. But
That's
yeah,
right.
she did stumble into Sunny.
Well, sir, actually, it was you who fell onto Sunny that night, isn't it?
No, I didn't stumble that night.
So if Mr. Mehta comes on the stand today and says that it was you who was stumbling that night, Mr. Mehta would be wrong as well?
If he says that, then yeah, I never stumbled that night. I was fine.
Mr. Levin, you'd agree with me. You're under a lot of pressure to testify today.
What do you mean?
Well, sir, after Jessica passed away, the first person the plaintiff came for was you, right?
So after Jessica passed away, her mother talked to me about a lawsuit. She talked about potentially suing me.
That's exactly what
That's you're referring to.
Excuse me. That's not exactly what she talked about. She told you she was going to sue you.
She said that, yes.
You know who the plaintiff is, sir, right?
Jessica's mother.
She's an executive at a multi-billion-dollar corporation, don't you say?
Yeah, I think so.
Well, sir, it was only after she threatened to sue you that you spoke to the plaintiff's attorneys. Isn't that right?
Well, technically, yes, but it wasn't like exactly after. She told me about the lawsuit right after Jessica died. I talked to the attorneys much later.
Sir, my question was a lot simpler. It was after the plaintiff threatened to sue you that you spoke to the plaintiff's attorneys.
Yes, that's true. I just want to be clear that it wasn't right after, it was later.
It was only after the plaintiff threatened to sue you, sir, that you decided to testify for the plaintiff here today.
That's true.
Mr. Levin, let's talk about what we can all agree on. You were with Jessica when she got in that car later that night.
I was.
Sir, you didn't stop her.
No, I tried to stop her, but she wouldn't listen to me.
Hold on, sir. You offered her to get into your Uber, right?
I offered her to get into my Uber. I told her I'd call her an Uber.
But you didn't call her an Uber, did you?
No, she refused.
You didn't take away her keys.
No, I didn't.
You didn't pull her from the driver's seat and make sure that your best friend didn't get into that car, right?
No.
And you weren't, excuse me, you weren't the only one there either, were you?
No, I wasn't the only one there.
You know that the employees, Sonny, and the bartender were also at the bar that night.
They were.
There were other customers, 10 other customers that night, right?
That sounds about right.
Your Honor, we're sharing our screen now with only what the witness has already told us about who was present at the bar. So there's people on the left of that screen there. That's everyone you saw at the bar that night, right?
Yes.
Jessica didn't stop herself from getting into that car.
No, she didn't.
Like we mentioned, you didn't tell Jessica to stop getting in that car.
I'm sorry, Your Honor, but I believe that the time has expired.
Right, I just saw that message. Okay,
Honor,
help me out.
we
on
have
the
a different time.
limits. Okay, help me out. I don't know what the time limits are or who's supposed to keep track of those.
Your Honor, both of our second chairs are currently keeping track of time. I have for my second chair that I have over a minute and a half left. So I think there must be some significant discrepancy there.
Right, and that's why I asked earlier if time was paused during various things. So from the defense side, you have a minute and what? Minute 10, minute and a half?
About a minute, Your Honor.
All right, we're gonna do a minute and then cut it off there. So you can proceed.
Yes, Your Honor.
So like you told us before, you didn't stop Jessica from getting into that car?
No, I wasn't able to.
Mr. Mehta, from who you met, didn't stop Jessica getting in that car?
I didn't see him do that. No,
Neither did the bartender,
no,
and neither did any of those customers, right?
no, they did.
Thank you. Nothing further, Your Honor.
All right, any redirect?
No redirect, Your Honor. We just ask that Mr. Levin be allowed to step down.
That's fine. You're excused. Thanks for your testimony. Any further evidence for the plaintiff?
Yes, Your Honor. Before we close our case in chief, we just like to read another portion of that third-party Reutemann deposition into the record. It goes to the credibility of the testimony they read on before. Could we get?
Go ahead.
Could we get page 3, lines 2 and 3 up, please? Question.
Okay, hang on, counsel. Do you have any objections?
Just one moment, Your Honor, for me to review it.
Right. This is why you're supposed to do this beforehand, but not a criticism of you, just of the rules.
Your Honor, we're fine with this.
Go ahead.
How much did you drink? A lot. I probably had 3 or 4 beers and a few shots, and that's referring to the night. With that, Your Honor, plaintiff rests.
All right. No further evidence from the plaintiff. Are there any motions allowed now, or are there no motions?
No, Your Honor. The only motions that are allowed are to invoke 603 and 615 in this
All right.
jurisdiction.
All right. That's too bad because I would have granted a motion and we could all go home early. Again, not a criticism of you, just of the facts. Is there any evidence on behalf? Well, first of all, do you need a break or do you want to proceed?
Plaintiff's ready to go right in.
We're ready to go, Your Honor.
All right. Evidence from the defense.
Yes, Your Honor. At this time, the defense calls Sonny Mehta to the stand.
Afternoon. You are muted. Can you unmute and say something?
Can you hear me okay?
Go ahead. You can proceed.
Good morning. Please introduce yourself to the court.
Hi, my name's Sonny Mehta.
What do you do for a living, Mr. Mehta?
Business owner. I used to work at Sonny's Rooftop Bar.
Where were you working in 2019?
Sonny's Rooftop Bar. I sold it about 2 years ago, but I had owned it for about 3 years before I shut it down.
What exactly was Sonny's Rooftop Bar? Can you tell us a little bit about it?
It was a labor of love. You know, when I was growing up, my mom told me that her dream for me was to own a business. And at the time, I thought that was crazy. But, you know, I fell in love with Sonny's. I really tried to make it a second home for our kids.
Sir, do you know who Jessica Marks was?
I do. She was a patron at Sonny's back in 2019.
I want to go back to the night that she passed away. Did you serve her alcohol that night?
I did. Yes.
Did you know she was 19 years old?
No. Her and her friend had fake IDs. So we didn't know that they were under 21.
Did you know at the time that she was going to drive after going to your bar?
No. She never mentioned that to me.
Well, sir, when she left, did you stop her from driving home?
No, I didn't.
Who else other than you was at the bar that night?
Well, obviously there were other customers there. Well, there was our bartender, Frankfurt, and obviously Jessica and her friend.
I want to talk about where you and all those people agreed. Your Honor, we're sharing our screen now with the same demo we used with Mr. Levin. Sir, do you see anyone on the left side of this screen who wasn't at the bar that night?
No, everyone was there.
Are we missing anybody?
No,
Sir, did any of these people stop Jessica from getting into that car?
no, no one did.
I want to talk about why that might be. Sir, do you ever stop people from driving home after going to your bar?
Of course, I care about my patrons a lot. And if I think that they might hurt themselves or do something unsafe, I do anything to make sure that they just get home safe.
Well, sir, how do you decide whether or not to let someone drive or call them a cab?
Well, when they seem visibly drunk or intoxicated, that's usually when I know maybe to call them an Uber or a Lyft or something.
You said visibly intoxicated or drunk. What kinds of things specifically do you look for when you're making that decision?
Well, it's different for everyone, right? But the first thing they teach you when you're taking your responsible beverage training is that you should look for, alcohol smelling breath, slurred speech, poor coordination, loss of balance, whether or not they can walk very well, whether or not they're being super loud or over the top, and also if their face is flushed.
I want to talk about how many of those signs you observed on Jessica Marks that night. Your Honor, we're sharing our screen with another demonstrative, with only what the witness has already testified to. So let's start with that first sign. Did you notice alcoholic breath on Jessica Marks that night?
No, I didn't.
What about her speech? Was it incoherent or slurred?
No, I talked to her a few times and it was never slurred or anything like that.
How about her coordination? Was she fumbling around?
No, not to my knowledge. She was walking around okay.
Was she losing balance or stumbling?
And not that I saw. No, she went down the steps a few times. She walked out perfectly fine.
Was her conduct loud or boisterous?
Well, it's a bar, so you have to speak up, but it wasn't too loud or over the top. No, it was normal.
And lastly, you mentioned you look at people's faces to see if they look flushed. When you looked at Jessica that night, how did she look?
She looked fine. I didn't think I noticed her face being flushed.
So the whole night Jessica was there, did any of that change?
No, sir.
Do you remember if anyone at that bar did show those signs?
Yeah. Actually, Jessica's friend, Morgan.
How was Morgan acting that night?
She was showing some of the telltale signs, right? She was slurring her speech. I gave her a tab and she could barely sign the receipt. I was honestly pretty worried about it.
Mr. Levin rather, he told us earlier that he saw Jessica stumble onto you that night. Is that what you remember happening?
No, I don't remember that happening at all. From what I remember, it was actually Morgan that stumbled on me once.
Sir, just to be clear, did you have a drink that night?
No, I stopped drinking on the job a long time ago.
And so when the end of the night came, did you let Morgan drive himself home?
No. From what I know, Morgan got into an Uber.
Mr. Mehta, we've talked a lot today about how Jessica Marks seemed to you. If I were to show you a couple of videos, do you think you'd be able to compare how she looked there to how she looked at the end of the night?
Sure, I could do that.
Your Honor, we're sharing our screens now with Exhibit 6 and the admitted Exhibit 10. Mr. Mehta, the video on the left there, is that familiar to you?
Yeah, I've seen that before while we were preparing for trial.
Are the clothes that Jessica's wearing there, are those familiar?
Yeah, from what I remember, that's what she was wearing the night she was at my bar.
Your Honor, at this time, we offer Exhibit 6 into evidence, same stipulations as Exhibit 10 as an authentic post on Jessica Marks's Instagram.
Counsel, any objections?
If the defense wants to enter Exhibit 6, we have no objection.
All right. 6 is admitted and 10 is already in. Proceed.
Mr. Leckery, if you can play Exhibit 6 now. Oh, Mr. Leckery, make sure that your
There's
audio
no
is
audio.
connected.
Yeah. Okay.
Just a moment, Your Honor.
That's fine.
You might have to unmute yourself, Mr. Leckery.
Hey guys, we're going out tonight for a night on the town. We're going to a rooftop bar in Hollywood. Should be fun. You know, go hard or go home. Not ready to go home.
And now, Mr. Leckery, if you could just play the first 10 seconds of the video on the right.
Hi everyone, Morgan and I are in Hollywood. We're in a bar. It's kind of like a Philly bar, except everything is really, really expensive.
Mr. Mehta, after watching these videos, which of these compares more closely to the way that Jessica was acting when you served her those drinks and you let her drive home?
The first one, like I said, when I was talking to Jessica, it really did seem like everything was okay. You know, we all thought it was okay.
Thank you, Mr. Mehta. Your Honor, at this time, no further questions, though we would ask permission to read one last portion of the deposition of Kendall Roitman onto the record.
Okay. You have a page in line.
Yes, Mr. Lecker, if you could just get it up real quickly so I can remember. Or rather, I have it. This is page 5, lines 4 through 13.
All right, counsel, I'll let you read and decide if there are objections. Let me know when
Thank you,
you're
Your Honor.
Yep, let me know when you're ready.
Yeah, we'd object to more misleading than probative, Your Honor. Just the fact that this witness didn't see her stumble when we've already heard testimony that this stumble occurred in the stairwell in a private area of the bar is likely to mislead the jury. They're trying to break the tie to show that this isn't a he said, she said situation when this witness really can't tell us anything about whether or not that fall actually occurred.
Right, so what rule says more misleading than probative can't be admitted?
Rule 403, Your Honor.
Right, that's prejudicial. And what part of it is it that you're actually objecting to? Line 5 and 6?
I didn't see her fall or stumble, if that's what you're getting at. Line 5 and 6. Line 5 and 6, yes, Your Honor.
Well, I want to. I guess I want to know what you're getting at in terms of your objection, and it's lines 5 and 6, right?
Yes.
Counsel, defense, do you have a response?
Yes, Your Honor. If the objection is that it's prejudicial or misleading, for it to be inadmissible under 403 on those grounds, it needs to be substantially more misleading or prejudicial than it is probative. The fact that an eyewitness is denying what their eyewitness said is very probative for the jury in today's case.
May I respond?
Yeah, go ahead.
The misleading value of that testimony under Rule 403 does meet that substantial standard under the balancing test, Your Honor, because there's no foundation on the record. There's no foundation in this portion of the deposition or any part of the deposition at all to suggest that this witness would have been in a position to see Ms. Marks fall in that stairwell. The fact that this witness didn't see it happen out on the patio has nothing to do with the event we're actually talking about.
Right, I understand that, but how is it unfairly prejudicial if the witness is accurately saying they didn't see something?
We don't believe it.
Go ahead.
I'm sorry, Your Honor.
No, go ahead.
We don't believe it is unfairly prejudicial. We believe it is unfairly misleading, which is an objection under Rule 403.
Right, okay, so if the statement is factually true, how is it misleading?
Because, Your Honor, even if the statement is factually true, it's not about the testimony we're hearing today. We're here to talk, excuse me, Your Honor. The specific event that we're talking about right now is whether or not she fell in the stairwell. They're trying to introduce this to show that she didn't fall in the stairwell, when in fact, it's not actually about the stairwell at all.
All right, counsel, for the defense, you're going to win, or do you want to respond?
Your Honor, I stand by my previous responses. It's a high burden for 403. And to what Mr. Demsky is talking about, that goes to the weight of the evidence, not its admissibility.
The objection is overruled. Proceed.
Starting at line 4 here. Question. Speaking of Jessica Marks. Question. Did you ever see her stand up? Answer, probably. She was there a couple hours, but I didn't see her fall or stumble, if that's what you're getting at. Question. How long were Jessica and her friend at Sunny's? Answer. Got there at 9, left after 11, so 2 or 3 hours. Question. Did you suggest to Jessica that she shouldn't drive? Answer. Me? No, I never spoke to her. Question. If you thought she was unfit to drive, would you have said something either to her or a bar employee? Answer. Maybe, yeah, I probably would have. Thank you, Your Honor. Nothing further.
Okay. Anything else with this witness?
Yes, Your Honor, cross-examination. But before
Proceed.
we cross-examine the witness, we just like to make Your Honor aware that we're going to be reading a line into the record during the cross-examination from a police report that is stipulated to be an authentic police report and is admissible as a public record under Rule 8038A3. As to the second layer of hearsay, if defense counsel is worried about that, the only statement we're going to be reading is a statement made by this defendant. It falls under the party opponent rule.
All right, I see this is authored by Sammy Gaskins, who may be related to Sydney Gaskins, who I met at this tournament last year. Counsel, are there objections to any of this, or?
Your Honor, we don't have a hearsay objection pursuant to the stipulation of 803A3A. However, I just like opposing counsel to note exactly what he's talking about in case there's another objection.
Sure. We're just going to be objecting to the line, and I'm sorry, Your Honor, the police don't appear to have put line numbers on here, but we're going to be objecting to the line. I spoke to Sunny Mehta, the bar's owner. Sunny said that Jessica Marks was a typical buzzed girl.
Okay.
Just so I'm clear, you said you're going to be objecting to that line?
Oh, no, Your Honor, we're going to be reading that line into the record.
All right, I want to make sure I didn't mishear you. Counsel for the defense, any objections to that?
Your Honor, we don't have an objection to that line, though I would inquire through the court if they're intending on entering this exhibit in its entirety, because we actually do have objections to another portion of the document. The line itself is fine, but there's other stuff in the document as well.
Counsel?
We're not going to enter it in its entirety, Your Honor. We understand there are some issues with the rest of the document, just this line.
All right, then you can proceed to read that portion into evidence at the appropriate time. Counsel for the defense, if there ends up being an objection later, you can renew it at the appropriate time.
Yes, Your Honor.
Yes, Your Honor.
All right,
Commissioner Cross?
go ahead.
Good afternoon.
Good afternoon.
I want to begin by talking about what you served Jessica Marks. You just told us that when Jessica left your bar, you didn't know she was intoxicated.
I didn't know that she might have been unsafe, but yes, I didn't know that she was maybe obviously intoxicated.
You said she didn't seem drunk to you.
No.
Mr. Mehta, you're aware that just because you didn't stop her from driving doesn't mean you shouldn't have stopped her from driving, right?
Sure.
You're aware that just because nobody stopped her doesn't mean they didn't need to.
Sure. I'm just telling you what I saw and the decision that I made then based on what I saw.
Mr. Mehta, let's be very clear. You personally brought over 9 drinks to Jessica Marks's table, right?
Between the two of them, yes.
Let's break that down, sir. You brought 2 shots with hard alcohol in them, right?
Yes, that was towards the end of the night.
You delivered 3 cans of hard seltzer with 8% alcohol.
Yeah, it's a White Claw.
You brought him 2 beers, a beer in a can and a draft beer.
Yes. Again, it was for the table. I'm not sure which of those Miss Marks actually drank, but I did bring it to her table.
Sir, you brought that table an entire bottle of wine.
I did. That was the first thing they ordered.
Of all of those drinks, Mr. Mehta, your understanding is that Jessica Marks ordered about half, right?
Yes. Obviously, I wasn't watching them drink all of the drinks, but I know that Jessica ordered at least half.
Sir, Miss Marks was 5 feet tall.
Yes.
You know, today she weighed 110 pounds.
Yes.
You're telling the jury that after you served this girl 9 alcoholic drinks, when she walked out of your bar, she looked stone cold sober?
To be clear, I'm not sure which one she drank. She was sharing them with another person. And really, people process alcohol differently. Nothing I gave her was, I didn't give her multiple shots, for example. So based on what I saw, she didn't seem very drunk.
Mr. Mehta, I'm going to bring you back to my question. You just told us that a 5 foot tall girl ordered about half of 9 drinks. And when she walked out of your bar, you're telling the members of this jury, as you sit here in court, that you thought she was sober.
I can say she was sober. I made clear that she definitely had been drinking some, but she wasn't going to be unsafe.
Let's talk about the opportunities you had to see how intoxicated Jessica was that night. You were waiting tables that night, weren't you?
I was. I love talking to my guests.
You took orders from Jessica and Morgan's table about 4 or 5 times.
I did.
You brought them drinks about 4 or 5 times.
That's true.
That's 8 to 10 times throughout the night that you were within feet of Jessica Marks.
Exactly.
Sir, you were in court today when we played Exhibit 10, that video of Ms. Marks, right?
I was.
You would agree that in that video, Jessica Marks looks intoxicated, right?
She seems like she's had a few drinks, but I can't say how drunk she was.
So that's a yes to my question. She looks intoxicated.
Yeah, maybe buzzed, something like that.
Now, it's your testimony today that you never saw Jessica Marks in a state like that, right?
No, that's not exactly what I said.
Sir, in your deposition, you told us when shown the video that you never saw Jessica Marks in a state like that, right?
I never saw her as loud as she was then. No.
And sir, it's your testimony that when you saw her, she was far less intoxicated than she seemed in that video.
I'm not sure how intoxicated she was in the video, but from what I know, she did seem less intoxicated when I was talking to her.
Sir, you went up to that table a couple times right around when that video was posted. You know that, right?
Yeah, I think it was around maybe 11 o'clock.
Let's put up exhibits 15 and 16. Sir, these are 2 pictures of Jessica Marks's table that were taken that night. You know that now, right?
Yes.
They look to you to be accurate?
Sure.
We offer the pictures, Your Honor.
I'm assuming you mean exhibits 15 and 16. Any objections?
Your Honor, given stipulations about when these were posted and that they're accurate, we have no objections.
All right.
Now,
15 and 16 are in evidence. Proceed.
Now, Mr. Mehta, your counsel has stipulated that exhibit 15 was taken at 10:57. The video we saw was posted at 11:11, and exhibit 16 was taken at 11:32. Can we get all that up on screen, Ms. Lowen? Thank you. Sir, you would agree. That means both of these pictures were taken within 21 minutes of when this video was posted, right?
That's true.
Sir,
Objection, Your Honor. At this point, I would object to substantially more prejudicial than probative, if I may explain.
Okay.
Your Honor, while we have testimony about when this video was posted, we haven't heard any foundation about when this video was taken. For the point they're trying to make, that she was drunk in between these, acting this way rather, in these moments between these 2 interactions, it's actually very important for the members of the jury to have a timeline of when it was taken, and they haven't provided that with this witness or with their previous witness.
may I respond, Your Honor?
Yeah, go ahead.
Both parties have agreed today that Jessica Marks's phone was damaged in the crash and that we don't have the metadata. We're showing when this video was posted to social media, which was at 11:11 p.m.
Right. And okay, so just let me pontificate for a minute. So there's a beer in both photos, I think a White Claw and a nacho bowl with blue diamonds on it in both videos, along with a wine glass. Counsel for the defense, I mean, I understand the argument that you don't know when this was posted, or you know when it's posted, but not when it was taken. But can you help me connect the dots as to why this is unfairly prejudicial, given those similarities?
Yes, Your Honor, because we don't know, given the foundation we've had, if the video it belongs in between these two exhibits or before the first exhibit. It is equally as likely, given with the foundation we've heard, and they had the witness who took the video before. They didn't get out the foundation about when the video was taken specifically. So at this point, it's prejudicial in a way, given how they're trying to use it now.
May I respond, Your Honor?
Well, you're going to win if you want, or
I'll take the win, Your Honor.
got it. Okay. The objection is overruled on the arguments that I heard, in part because your own witness agreed that the video was taken within 21 minutes of Exhibit 10. And I mean, your witness agreed that the video is contemporaneous. So the objection's overruled. Proceed.
Sir, you would agree with me that within 21 minutes of that video being posted, you went up to Jessica Marks's table and you refilled the water corral, right?
Yes,
Within 21 minutes of that video, you went up to that table and you took away the chips and guacamole, right?
that's true.
Within 21 minutes of that video being posted, you went up to the table and you took the wine glass away, right?
Yes.
Sir, within 21 minutes of when that video was posted, you refilled the beer at that table.
Yes.
So let's talk now about what you said about Jessica Marks after she left your bar. Now, you're claiming today, Mr. Mehta, that she seemed okay to drive, right?
That's true.
You're claiming you didn't notice obvious intoxication. I noticed those were your words earlier today, right?
She didn't seem obviously drunk. No,
But sir, that hasn't always been your story, has it?
I'm not sure what you mean.
Sir, you spoke with the police a day after this crash occurred, right?
Sure.
And your conversation with the police, it happened before anybody filed a lawsuit against you.
Yes.
It happened before your bar was put on trial.
Yes.
It happened before you hired Mr. Nerurkar to represent you, right?
Sure.
And when you spoke to the police, you didn't tell them that Jessica Marks looked to you to be fine to drive, did you?
I said she was a bust. That just means maybe one drink, but you're not really drunk or unsafe. I definitely didn't say that she was drunk or unsafe to drive.
Sir, that's a yes to my question. You didn't say she looked okay to drive.
I didn't say those words verbatim. I said she looked like any typical girl that had drank maybe one drink at a bar, one or two, and looked fine. That's all
But
I
see, Mr. Mehta, you didn't say any of that second half of that sentence. All you told the police was that Miss Marks was a typical buzz girl, right?
I didn't say those words verbatim. Yes, I told them they were a typical buzz girl. Buzz just means that it's not drunk, but it means you've had a few drinks.
Sir, I understand you want to explain yourself. That is a yes to my question.
Sure.
Thank you, Mr. Mehta. Nothing further.
Any redirect?
There's no redirect at this time, Your Honor. At this time, the defense rests its case in chief. We're ready to proceed to closing arguments if the plaintiff's ready to.
All right, the witness is excused. Thanks for your testimony. And I know defense is ready. Plaintiff, do you need a break or do you want to proceed? It's up to you because you go first.
If I could just have 30 seconds, Your Honor.
All right, let's take, why don't we take a minute? That'll give you guys time to prepare. I'm going to mute and shut off my camera.
Defense is here, Your Honor.
All right, we're all here. Let's proceed with closings. Plaintiff, go ahead.
Yes, Your Honor. What they served, what they saw, what they said. It's March 24th, 2019, and Sonny's bar is slowly getting quieter. One by one, people are trickling out into the warm night air. Something terrible is about to happen. Jessica Marks doesn't know it. The people still drinking in the bar, they don't know it. My client, Ethel Marks, certainly has no idea what is about to happen. And members of the jury, I don't need to tell you exactly how Jessica Marks died that night because, of course, you do know. We all do. But on March 24th, 2019, there was only one person who should have known what was about to happen, and it was the one person whose job it was to know, whose job it was to make sure Miss Marks never ended up in the situation that caused her death in the first place. The defendant's owner, Mr. Sonny Mehta. So what does he do? Does he tell Jessica, I'm sorry, you've had enough, it's time to go home? Does he tell her friend not to let Jessica behind the wheel of a 2,000-pound death trap? Does he offer to call a taxi? No. He looks Jessica in the eye and he pours another drink. Members of the jury, I don't even need to open this door and show you all the alcohol Miss Marks had that night because you know exactly what's behind here, just as sure as the defendant knew what they'd been serving her. But I will anyway, ladies and gentlemen, because the sheer volume of it is astonishing. I mean, they serve a 5-foot-tall, 19-year-old girl an entire bottle of wine, 1, 2, 3 spiked seltzers, a beer, and an alcoholic shot. These drinks are why we're here today. These drinks are why we've sued the defendant under the California Dram Act for wrongful death. Now, in cases like these, members of the jury, the law is crystal clear. Bars, they have a responsibility to stop serving alcohol to people who are obviously intoxicated. And when they ignore that responsibility, when they, 1, serve alcohol to someone who's clearly impaired, 2, that person is a minor, and 3, someone gets hurt as a result, they can be held liable. We've proven all that today by a preponderance of the evidence, and to show you how, all you need to do is look at what the defendant served, what they saw, and what they said. So first, what the defendant served, and what I want to do here, members of the jury, is take the defendant at their word, just for a second. Let's imagine they really were so blind that they never saw Jessica slurring her words or stumbling down the stairs, that they never saw her red, watery eyes. Even then, what they cannot get around, what Mr. Nerurkar can't avoid, is the sheer number of drinks they served to Jessica Marks that night. Because it's common sense. When you serve someone who's 5 feet tall and 110 pounds, 6 drinks and the better part of a bottle of wine, she's going to get drunk. Even if they saw nothing, they knew what they served her. And if that amount of drinks would lead to obvious intoxication in someone like Jessica, members of the jury, they should have known. But of course, it gets so much worse for the defense because you can't take them at their word, because they did see what was going on. And that brings us to number 2, what they saw. We showed you Exhibit 10. You saw exactly how Jessica was acting that night, yelling, swaying, slurring her words. This isn't covert behavior. It doesn't take a special certification to look at somebody like that and say that person's drunk. But here's the thing, members of the jury. The bar that night, these are people who literally, their job is to spot drunk people. And they expect us to believe that that girl, I mean, you saw the video, she could barely sit up. She just slipped through their fingers. The defense, they want you to believe they were never around when Jessica was in that state. But we know that's not true. Not just from what Morgan Levin told us about the video, but Sonny Mehta admitted himself that he went back and forth from that table 8 to 10 times throughout the night. We know he came up to that video within 21 minutes of that video being posted. He moved stuff on the table around and he poured Jessica Marks another drink. It's common sense, members of the jury. They saw it, they knew it, and there can be no doubt about it because they admitted it. And that brings us to what they said. I hope this one's not driving. We might need to cut this one off. That's what our third party witness, an impartial person who was there that night, a friend, actually heard. Members of the jury, don't believe the defendant when they say that never happened, because their business is being sued and they have every reason to lie. If a bartender speaking out loud about needing to cut someone off isn't proof that they're obviously intoxicated, then folks, what is? Members of the jury, the most interesting thing about this case, what makes this death all the more senseless and infuriating is how little this defendant had to gain. You know, if this were a case about greed or hatred or jealousy, then maybe it'd make sense what the defendant did that night. I can't tell you what Mr. Mehta was thinking when they went back to that table. Maybe they really needed the extra $40 from those drinks. We just don't know. But whatever it was, members of the jury, Sonny Mehta made his choice on March 24th, 2019, and now it's up to you to make yours. Find the defendant guilty. Liable. Thank you.
On behalf of the defense,
Yes, Your Honor, may I proceed?
proceed when ready.
May it please the court, Mr. Demsky, members of the jury. Everyone agreed. Those aren't words you hear too often in a trial. I bet over the last couple hours, you're getting pretty used to disagreements. Attorneys versus attorneys, witnesses butting heads with the attorneys, plaintiff and defendant. But this case isn't about where we've disagreed. It's about agreement. About where the 5 people who really matter agree. The 5 people who saw Jessica get into her car on March 24th and could have done something about it. The 5 people who looked at Jessica Marks and the 5 people who agreed that she could drive. We've been talking about this piece of evidence all of today. So why does it matter? Well, members of the jury, it's been the plaintiff's job throughout today's trial to disagree with those 5 people. They've had to prove to you today that Jessica Marks was obviously intoxicated when she left that bar and when they were serving her those drinks. And not just obviously intoxicated to us now, years later, obviously intoxicated to the bartender and the bar owner. What exactly does obviously intoxicated mean? We talked about this briefly in my opening statement, but let's get into it in some more detail. Because one thing the law tells us it doesn't mean is that it doesn't mean drunk. In fact, the judge is going to tell you when you deliberate that how much someone drinks is not sufficient evidence to say that they were obviously drunk. Now, we gave you an example of how a reasonable person might decide someone is obviously intoxicated. It was from Mr. Mehta himself. Now, let's look at what he actually said. He gave you all the signs of intoxication that he looks for. He looks for as a bar owner, someone whose legal responsibility it is in California to make sure people get home safe. And what happened when he looked at Jessica Marks that night? He checked for alcoholic breath, wasn't there. Checked for incoherent and slurred speech, wasn't there. Look for poor coordination. Her coordination was fine. You go down the list, members of the jury. After all she drank, after all the plaintiff says she drank, she still didn't show those signs. Now, after all that, you still might not buy Mr. Mehta's signs of intoxication. You might think, hey, that's subjective. Everyone has their own way to determine if someone is obviously intoxicated. Reasonable people can disagree. But one standard that I think we can all agree on is that if someone is obviously intoxicated, they're not suitable to get behind the wheel. And members of the jury, if you want evidence that she wasn't obviously intoxicated, look at the decisions of the people who matter. Look at the bar owner and bartender. Mr. Lecker, you can take it down. The bartender and the bar owner, whose legal responsibility it was to keep track of her. Look at the other customer who we heard today takes it as a personal responsibility to make sure people who are too drunk don't get in the car. Take it from Jessica herself, who's looked at herself, looked at her driving capacity, and didn't think she was obviously intoxicated. Members of the jury, look at the plaintiff's own witness. Now, we have some questions about Morgan Levin's credibility, but one thing we don't doubt is that Morgan Levin was best friends with Jessica Marks. One thing we don't doubt is that when his friend got into a car, he was concerned for her safety. Now, the plaintiff calls Morgan Levin, and they try to use him to show you how much Jessica drank that night. Members of the jury, this witness should have been a slam dunk for the plaintiff. He should have been able to take the stand and say, after all those drinks I saw her drink, I made sure she didn't drive herself home. She was my best friend. She was obviously intoxicated. Of course I didn't let her drive. I pulled her from the car and put her in my Uber. But what did we actually learn today in court? We learned that when his best friend went into the car next door, he wasn't worried. He wasn't worried, just like the bartender and the bar owner weren't worried, like the other customer weren't worried, because they all agreed that she could drive. So you realize after listening to the plaintiff's own witness, that for the plaintiff's case to be true, you have to believe that their own witness lied to you about being her friend, that he was wrong when he told you that she's been my best friend for years. You have to believe that for a moment, those bar owner and the bartender forgot their responsibility. You have to believe for a moment that that customer completely forgot his personal principles. Now, are one of those things likely? Sure. If two of those people forgot all those things, is it possible? Of course it is. But members of the jury, if all five people agreed, what's more likely? Now, as the defense, we have the misfortune of not being the last person to speak to you today. And Mr. Demsky, he gets to come up here one last time and speak to you. But as he does, see if he can answer that challenge. See if he can bring you one person who was there that night and didn't think Jessica Marks could drive. Because if he can't, members of the jury, it's 5-0. It's five people who were there looking at Jessica that evening and didn't think she was drunk. They all agreed that she could drive. Members of the jury, there's no doubt they were all wrong, and she shouldn't have gotten in that car. But it's not about what we agree on now. It's about what they knew then. That's why the plaintiff hasn't met their burden today. That's why we'll ask you to find Sonny's Rooftop Bar not liable. Thank you.
Thank you, counsel. Is there a rebuttal?
Yes, it's my understanding I only have 30 seconds.
All right, proceed when ready.
Mr. Nerurkar's legal argument would almost be elegant if it weren't dead wrong. Because the judge is going to instruct you on the law, and you're going to learn that it doesn't matter whether or not everyone agreed she was safe to drive. It matters whether or not the defendant should have known that she wasn't. Ladies and gentlemen, they said it's 5-0. Morgan Levin told you himself he didn't think she was okay to drive. We know from what they served her, what they saw of her, what they said to her, that she was obviously intoxicated. Now find him liable. Thank you.
Thank you, counsel. The case is submitted. Hang on, I have a very old dog here who is going to need to go outside in a minute. So judges, you can complete